Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back. I promised you an update on the Kouri Richins case, and here we are. Finally got everything together to go ahead and give you the latest on that. But before we begin, please do the YouTubey things, like and subscribe. Also, turn on your notifications so you know when I'm coming back on to tell you something else that's going on in this crazy world. All right, so let's dive deep down into the Kouri Richins case. I'm going to give you a road so far. I'm sure you know a little bit about this. So here we are. Kouri Richins versus Utah. Kouri Richins was married to Eric Richins. They have 3 children together. She owns a real estate company. She would buy houses and flip them. He owned his own real estate, or not real estate. He owned his own like construction masonry company. She bought a mansion after he passed away. So what happened to Eric? Eric was 38. What did Kouri have to gain? Oh, okay. So let me. Kouri Richins is accused of murdering her husband, Eric Richins, by giving him 5 times the legal dose of fentanyl in a Moscow mule. Whether what she gave him to him is in dispute, but we'll go over that in just a minute. She had previously tried to give him a fentanyl breakfast sandwich. That didn't work. He had a bad allergic reaction. That was on February 14th. And then she had asked for more fentanyl in her text messages and documents. And long story short, Eric ends up deceased. So she even wrote a book about grief for her children. Are You With Me? About the death of her husband, so it could help with her children cope. And she went on a tour of promoting her book. Yes. So, Sky Lazaro was her previous attorney. There is a conflict of interest there, so she had to get off the case. There's a whole big thing about that as well. She wrote this walk the dog letter. The dog letter is in controversy because Kouri says that it is attorney-client privilege. But in it, there's not much about it. She also said she was writing a book, but if we have gone over it in the previous stream, it basically is a letter to tell her mother and her brother how to testify or what to say. That is coming in. This is coming into evidence. So she's got a new defense team, and we talked about what the state alleged, and then this is what's on the docket. But why is all of this popping off now? She's getting ready to go to trial in January, but there is so much going on. So I'm going to go ahead and show you what the latest and greatest is. So this is an article asking or talking about, let's see if I can make it a little bit bigger. Get me out of the way, make that bigger. Let's see, does that make it bigger? No, that brings me back. Sorry. All right. Well, I'm going to read it to you. It is from Park City, Utah. Attorneys for Kouri Richins have asked Summit County Judge to reconsider her detention. She wants to get out of jail on bail, arguing that new testimony underlines the prosecution's evidence linking the Park City woman to the fentanyl overdose of her husband, Eric Richins. In a reply filed October 23rd, defense attorneys Wendy Lewis, Catherine Nestor, and Alexander Ramos have said that a key state witness, Robert Crozier, has now testified under oath that he did not provide fentanyl to another witness, Cameron LaBure, contradicting earlier claims central to the state's case. Prosecutors have previously alleged that LaBure bought fentanyl from Crozier and supplied it to Richins, who they say used it to poison her husband in March of 2022. The defense motion notes that the state has conceded the pills in question were never recovered or tested. The elimination of the state's alleged link of fentanyl to the defendant is a material change in circumstances. Without it, the state can no longer claim the existence of substantial evidence sufficient to support a denial of bail. Richins' attorneys argue that Crozier's sworn statement fundamentally changes the evidentiary record that led to her pre-trial detention. They're asking judge to hold a new in-person hearing where Crozier can testify to the court and can evaluate his credibility directly. It's never the job of the prosecution to determine the credibility of a witness. Go away. Richins faces multiple felony charges, including aggravated murder, and has been held without bail since 2023. Her defense team previously sought a release under certain conditions that was denied. A new motion does not ask the court to dismiss the charges, but Kouri wants to be out on bail. And the judge has yet to schedule a hearing on this matter. So what the heck is going on? So supposedly, Robert Crozier stated that he did not provide the go-between between Kouri and Crozier, which was Lauber, if I'm pronouncing it correctly. Didn't provide her with fentanyl. He said he provided her with Oxycontin, or I'm not sure exactly what he said, directly what he said. So a lot's been going on. We're going to, so in order to get court documents in this case, it is expensive. I don't have those funds currently right now. I am just starting out. I don't have any sponsors. So getting paid takes a while. So as I'm building things up, we'll get paid. We'll go into all these cases and get access to things. Plus also, I'm not a lawyer. Some ways to get access to court documents is you put in your bar license. Don't have one. So we are going to clip a clip from my one of my lovely law tubers, Emily D. Baker. If you don't know Emily Baker, you should. She is a lawyer who, oh, that is not a good freeze frame for you, Miss. Let's move this just a little bit because that's not nice. All right, here we go. I freeze framed her and she was in a terrible position and that wasn't nice. So before I bring her on, I had to fix that. Emily D. Baker has been a lawyer in California for, I don't know, let's say 18 years. Don't quote me on that. She lives in Tennessee now. She does LawTube on YouTube. She has 850,000 plus subscribers. She gets paid promotions and stuff. So she's been doing this for quite some time. And she is fabulous. She breaks things down for you. So we're going to go ahead and clip her, but I will also tag her when I post everything. So she did a lovely deep dive into the Kouri Richins case. She probably is going to do better than me, but we'll hear her talk about the docket, etc. So here's a taste of Emily Baker. Let's see what she has to say.
Literally just... Emily, you should have printed a PDF. I know. I just wanted to pull the whole thing. I really did. I just wanted to pull the whole thing. Here, we're just going to do it this way. There we go. Plaintiff, State of Utah, and their attorneys, Margaret Olson, Bradley Bloodworth, Joseph Hill, not Jonah, Joseph Hill, Byron Burmeister, and Lindsay, Chevernak. And then all the defense attorneys, Wendy Lewis, Kathy Nestor, Alexander Ramos. I don't know why they have Brad Bloodworth listed as a defense attorney. That's funny. He's not. They've got the charges listed, and then we're going to do a real quick scroll because we need to get down well past these early docketed items, and I'm not going to bother you as we scroll past hundreds of docketed items. We're in the thousands of docketed items now, so we need to get into those later docket numbers. And I want to make sure that we get right where we need to be. All right. June, July, October. Here we go. So as we get into the docketed items that we covered last time, we covered the motions regarding getting witnesses, attorneys. We covered the motion where the defense was like, this witness upends the entire case. Everything the state has said is fucked. Everything's changing. I don't see it that way, but that was their motion. That's where we are in the docket right now. So the date over here is, September 24th is the top one we were looking at. The motion to reconsider bail, we covered. And then things started popping up on the docket. The last time I pulled everything, these should have been on the docket, but they weren't. They just started popping up. Sealed. Ex parte motion for approval of defense costs. Fair. That is between the defense and the state of Utah and the rest of it. And they sealed that. You'll always see that motion to classify something as sealed. Well, not always. You will generally see it. We talked about the motion to compel on the sister-in-law. And then as we get down into this, we have a motion to classify documents as private from October 16th. And then we start seeing the rest of this. This is a proposed order to classify documents as private, and then they are classified as private. Affidavit and declaration of Brad Bloodworth, affidavit and declaration of Travis Hopper. Then we have the state's opposition for the motion to reconsider bail, which we covered. Then this is on October 20th. And again, these motions of Bloodworth and Travis Hopper may be related to the witness who the defense is saying flipped because they had those conversations. So in the your shit's flipped, those could be related to that motion with regard to bond because there was stuff sealed in that motion. But then on October 20th, we have a motion to classify the state's motion for an order to show cause as private and another motion to classify the affidavit of Brad Bloodworth as private. Orders to show cause are generally regarding, like the ones we're seeing in the Cardi B case. That one's over sanctions. But an order to show cause is a judicial procedural mechanism to say, hey, explain. It's literally an order to explain yourself. Excuse me. Can you please explain why, how, what the fuck? What we don't know is what this order to show cause is regarding. But it's what we're looking at now because everything else that's going on, we've seen. We know that counsel got appointed for the witness, Robert Crozier. Fine. We saw all of that. We covered it. There is a sealed second affidavit of Brad Bloodworth the next day, October 21st. And then we saw that there were other counsels appearing. We covered that. Defendant's reply to the state's opposition to defendant's motion to reconsider bail. We talked about all of this. But there's another sealed motion to classify notice of supplemental authority in support of the state's motion for an order to show cause. That's on October 30th. We don't know what the OSC is about. What is the order to show cause and why? But then it gets even weirder. In between, so docket 1092 is a sealed non-public information notice of appearance of counsel. So another attorney has filed an appearance, literally announcing their arrival on time. And then this is all on Halloween. And then in quick order, we have numerous sealed documents, including appearance of counsel, notice of limited appearance for attorney Alexander Ramos. Why does defense counsel have an attorney appearing on the record? I can only presume, and this is me presuming. Raina in the chat said, I didn't get a baby penguin. They will be sent to your in-game mail within like 3 days. They won't arrive today because once everybody downloads from the stream today, they will get sent out. So do not worry. Why is an attorney appearing for defense counsel Alexander Ramos unless it is regarding the OSC? Because that's the reason you would want to know. This is the reason you would want an attorney to appear. Just like Ron. Ron's like, hey, Your Honor, if we're having an OSC, I need my own attorney. So now we have an appearance of counsel for attorney Alexander Ramos, defense counsel, and then the motions to classify this as sealed. And then someone filed non-public information privilege communication, which could be a lot of things. It could be communications between attorneys. It could be attorneys and clients. But there is some type of privilege communication that is also sealed, all on the same day. All on the same day. Still on the same day. There is a motion to classify attachment 2 to the state's Rule 16 witness and exhibit disclosures as sealed. I think those are related to docket 1102, which is the state's witness list. I don't think these two sealed documents have anything to do with that order to show cause. Then, the same day, this all went down on Halloween, the same day. There is another privilege communication motion to strike filing of appearance and remove from the court docket. So they are not just striking the appearance, they're removing it from the docket. This appearance up here. This appearance of counsel. We still know that it's an appearance of counsel for defense counsel, but the filing has been stricken and removed from the docket. And then the court issued an order on November 3rd that's just completely private and sealed. I can only imagine that it's relating to all the stuff above. Because granting a motion to keep a witness list sealed is, hey, we're sealing the witness list. That's not a big deal. Then, also November 3rd, there is a non-public information memorandum in opposition to the motion for an order to show cause. What is happening? Lucy in the chat said, is Ramos the paramour? Hopefully not.
Okay. So, as you can see, Emily's fabulous, right? And she has access to that, and she did a fabulous job, much better than I could have ever have done. She obviously is a lawyer. She knows the ins and outs of things. She knows what's going on. So, as you heard her say, why does Ramos need an attorney? Well, we could speculate, as Emily has stated, we could speculate that perhaps he was the one that went to Robert Crozier, got the affidavit, he had changed up his information. So therefore, there's an order to show cause as to how and why this happened. Again, we don't know what's going on. We don't know what the order to show cause is. We don't know what the heck is happening. So there are some things happening behind the scenes that we, the public, are not privy to. The judge in this case is not thrilled about prior proceedings that have been televised throughout the country. He is not one to have a camera in his courtroom. And with lots of shenanigans going on, he is more likely than to want to have cameras in the courtroom, which is sad because, you know, we like to show you, we like to have these things and go over them with you and do gavel to gavel coverage and let you know what's happening. Prior to this, he was allowing fixed cameras in the courtroom, similar to the Koberger case, and I'll talk about that in a second. He was able to have fixed cameras in the courtroom, but he didn't release it. It wasn't streamed. I think they released it the next day or later on. So it wasn't being live streamed, but it was recorded and given out. The public has a right to attend trials. Anytime there usually is a hearing, the public is allowed to view the hearing unless it's closed for whatever reason. Sometimes they want to keep the public out if it's like a high profile case and they don't want the public to know about certain things. Could be there might be a child involved, etc. Anyways, so her hearing, the jury trial, if they choose not to have cameras in the courtroom, you as a public can go view it in Utah where she's being tried at, but you're not able to see it live streamed. So that is still up in the air, and the judge has to make that determination as to whether or not he is going to do that. Now, in the meantime, there's other stuff popping off. So we're going to now take you to a broadcast that her attorneys made on the news. And this is it's just wild. So let me bring this up. And it's like, what the heck is happening? What the heck is happening in Utah? So let's see. All right. Here we go. All right. So we're going to watch this together. Here we go. Oh, I got to share it first. It's got to get on the screen, silly woman. All right. Here we go.
In an unprecedented move,
we were willing to take an unusual step of coming forward.
Look, I never thought I would be sitting here.
Kouri Richins' attorneys,
she is distraught. She is heartbroken.
Reached out to 2 News Investigates.
That's exactly why we came here. And really, it's an ethical.
So, Emily's, I'm going to sort of parody what Emily had stated is like, what is going on in their newsroom? What the heck is all of this? Why are they showing sort of behind the scenes stuff? Why are we angled in a different way? I mean, like, this is just not flattering. So I don't know what they're doing here. So we just got to bear through it.
Duty.
We have a lot of confidence in you.
To set the record straight.
One thing that's been reported on that they have let go, have not corrected.
If their goal is justice, they have not lived up to it, at least in this case.
A 2 News exclusive.
And I feel that when I see these narratives come out, it becomes a game. It becomes another line. And we forget that there's somebody on the end of that. And that's a client. That's a human. That's a mother.
A Camas mom charged with murdering her husband.
The narrative is that your client is the Moscow Mule murderer. Is that accurate?
A narrative of alcohol, drugs, and greed.
There are certain things that are out there that we know right now, sitting here today, just aren't accurate.
And her attorneys say false information.
I do think the prosecution has declined to correct false information that has come out in the media. And we've waited and hoped that would occur, and it never has.
Tonight, Richins' attorneys speak out only to 2 News Investigates.
That's a very, very different narrative.
Camas, Utah, a small town in Summit County with about 2,000 residents. Among them, Kouri and Eric Richins and their 3 boys.
Their family was so beautiful. Everything was picture perfect.
Linda King used to work with Kouri Richins at Home Depot and remembered Eric, who was a contractor coming into the store.
You could never forget his laugh. And I love that laugh so much.
Linda says she encouraged Eric to ask Kouri out after she caught his eye.
I says, go over there and check out with her, so they did. Anyway, they ended up having a date. From then on, they were like glued to each other. It was perfect, I thought.
Perfect until March 4th, 2022, when Eric was found dead inside the couple's home. Police originally ruled that there was no foul play in Eric's death from fentanyl. Then a year and 2 months later, things changed. On May 8th,
Okay, I'm going to pause there. Why did things change? We talked about this a little bit before. Again, we talk about your phone. They weren't able to crack Kouri's phone. Finally, they were able to get the code, found information on her phone, found the text messages, obviously, from her and the go-between, Laubert, I believe is the name, and Crozier, and found out that she was asking for fentanyl and or pills or whatever the circumstances are. So that is why the trial was, sorry, that is why it was delayed in charging her with his death. Let's continue.
2023, Kouri was charged with her husband's murder. Prosecutors have added additional counts of financial crimes as well. As of today, Kouri's charged with aggravated murder, attempted criminal homicide, 2 counts of insurance fraud, and forgery.
Wendy Lewis, and I am lead counsel in the Kouri Richins case.
Kathy Nestor, I am one of the attorneys on the Kouri Richins case.
Alexander Ramos, co-counsel on the Kouri Richins case.
Wendy Lewis, Kathy Nestor, and Alex Ramos took over as Richins attorneys in May of 2024 after her previous attorney declared a conflict in the case.
What we came in here today were to focus on 4 very serious areas that have been absolutely factually reported incorrectly and that have been discussed publicly in court, in open court. I do think the prosecution has declined to correct false information that has come out in the media, and we've waited and hoped that that would occur, and it never has. And so that is why now, at this moment, at this time, we're coming forward and saying, well, then we're going to correct it. So,
Okay, let's pause there. In cases that have, okay, is it right for a prosecutor and or a defense attorneys to come into the media and discuss the case in certain circumstances, right? As you see, they're going to tiptoe around what exactly they're choosing their words very carefully because they cannot disseminate exactly what their case is about and what evidence they have. So they're tiptoeing around the subject here. In Kouri Richins' case in general, one of the things that they wanted to do is they wanted to change a venue because Camas is small, right? Summit County is very small. And a lot of this is dictated from their client. Kouri wanted to have it changed to a larger area in Utah and wanted to move everything. They did an extensive motion about this, and the judge declared no. He stated that, typically what happens is a jury comes in, they start answering the questionnaire, the voir dire that we just talked about in Brian Walsh's case. They ask him a whole bunch of questions. And in those things, they say, what is your level of XYZ? And in some cases, I don't recall if it's this one, I think this might be the one where the judge said, listen, if somebody has heard about this case, we just get rid of them immediately. We don't even stop to question. And if we can't get a jury here, then we'll move somewhere else. I think that's what this judge said. I'm not 100% sure. Long story short, you don't see defense attorneys and you don't see prosecutors coming on and start giving out things. In the Karen Reed case, it was very abnormal for the district attorney, Michael Morrissey, to come on and publicly announce the investigation that into John O'Keefe's death and the people and the players within the case. That is absurd, and that was well before her trial was to come out. You're talking about tainting the jury, right? You're putting ideas and bringing light to the case before the case gets to trial. And again, you want a jury who can be independent, don't have any information about the case, who haven't formed an opinion about the case. And here they are talking about it. And just FYI, the prosecution's not going to come on and say, "Oh, bad, we made a mistake." We'll go over this just a little bit further, but this interview, not good, not good. And so all that stuff with the docket, this might be another reason as to the judge just going cuckoo bananas saying, "What the heck are you guys doing?" Let's continue.
So that's where we are, and that's why we're here.
First up,
The narrative is that your client is the Moscow Mule murderer. Is that accurate? Can you confirm what the murder weapon is?
I can't confirm what the murder weapon is because the prosecution has never told us their theory. They have never said.
Okay, I have to stop there. Okay. It's alleged that Kouri gave him a drink. She made a drink. Was a statement from her. She made a drink, she gave it to him, and therefore he has to state, you know, they don't have to state where it came from. It's the fact that he was overdosed, right? And the state doesn't have to come out and say specifically. They just have to, means, motive, opportunity, blah, 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 blah. That's all that they need to do. So their statements are just so prejudicial. Anyways, let's continue.
That it was given in a Moscow Mule, that fentanyl was distributed or in a Moscow Mule. During the preliminary hearing, their lead detective was on the stand, and I asked him the question, sitting here today, do you know how Kouri Richins administered fentanyl to Eric Richins? And he said, no. The prosecution has never said that it was in a Moscow Mule. That came up because there was discussions, and I believe a statement by Ms. Richins early on, that she and her husband had drank a Moscow Mule before dinner. So that was something that was just grabbed onto. It's sexy, it's interesting, the Moscow Mule murderer, but the prosecution has never said that that is their theory of the case, not once. I still, sitting here today, don't really know how they're going to claim that Eric Richins ingested fentanyl.
Does the prosecution have an obligation to correct the record, the public record of this?
I mean, it's the prosecution's job to bring justice. That's what you do as a prosecutor. As a defense attorney, you protect your client's right. A prosecutor needs to find justice, fight for justice. And I believe by not correcting the record, by letting falsities sit out there, that's not what is happening now.
Okay. I'm going to stop it there. All right. So let's talk about this, right? She's saying the prosecution should correct the record. Well, how are they supposed to do that? We talked about this before. When you are charged with a crime, you get documents, the papers that are filed, and they say, this is what is alleged to have occurred. Here are the facts of the case. This is what's happening. And then as you go along, there are motions that say, hey, we're going to bring this into evidence. This person's going to testify, back and forth. And then it's the defense's job to go and say, no way, this can't come in, judge, because XYZ, motions in limine. And they go back and forth and they talk about it in the papers. They have to state case law. Why can't this come in? Why should this be let in? And they go back and forth and they argue. And so that is what normally the public doesn't see all of that, right? It's only us in the law tube world that are really interested in these cases and what the law has to say, etc., that we know sort of the behind the scenes of what's happening. Typically, your average juror just walks in and says, hey, I might have seen this case on TV. I might have saw something on YouTube. I might have saw something on the Tickety Talk or the Facebook or the Instagram, and maybe they knew something about it. I mean, one thing is I've never heard her called the Moscow Mule Killer. That might be something local. But again, if that is something local and the local people know about it, perhaps they need to change a venue. Again, all of these things are just circumstances with which they need to delve into. But what she is saying here is that the prosecution needs to come on the record. They need to get justice, right? We talked about this in the Karen Reed case. We talk about it in every case, right? Do they have enough evidence to put forth that this person is guilty of this crime? They have to prove it with beyond a reasonable doubt. And that's their job. That's the prosecution's job. Look at everything, look at the evidence, then present it to a jury, and then see how it falls, right? In some cases, people often wonder, you may not have had enough evidence in this case. Why are you putting this forward? Like the Karen Reed case. You got a lot of holes, you got a lot of controversy. Why do it? And why do it twice? Because Karen Reed was tried twice. In this situation, the prosecution has a strong belief that their case is solid, therefore they're going forward. But they don't come out publicly and say, oh, hey, we said this, but it means this. That stuff is argued in papers. And the prosecution doesn't have to correct the record for anything. That's what your court case is about. That's what the jury trial is all about. But here, she's going over this in the court of public opinion. So let's continue.
We'll see what happens in the courtroom, but that, in our view, is something that they should have corrected.
Can you confirm then that the fentanyl was administered in the Moscow Mule, given what you just said about the lead detective O'Driscoll? He couldn't confirm it, correct?
We cannot confirm what their theory is. We believe Ms. Richins is innocent. And, we're not here to convince you or anyone else that she's innocent other than those 8 people that are in the box at the trial. Those are the people we need to convince that she's innocent. So that's not why I'm sitting.
Okay, I have to stop really quickly. She's saying we have to convince the 8 people that are in the box. But who is she talking to right now? Is she talking to the potential 8 people in the box? Is she tainting the jury right now? Let me know in the comments what you think.
Here, but we do want what is accurate to be out there. A lot of it will come out at trial, but there are certain things that are out there that we know right now, sitting here today, just aren't accurate. And the Moscow Mule appears to be one of them. Now, since they have not ever said to us exactly what they think their theory is, I suppose we could be surprised at trial and they'll say, oh, it was the Moscow Mule after all. But they have never stated that in court ever, or in any pleadings or in any way.
The prosecution has painted your client as the Moscow Mule murderer. What is your opinion on that?
The Moscow Mule has never been stated in open court as being used to cause someone's death. I'm not sure where the press came up with that, but the lead detective has testified under oath that as of now, he does not know how fentanyl arrived in Mr. Richins' body. And so the press claiming that there's a murder weapon, that this was it, is just wholly fanciful. It just didn't happen. And it's not ever been said by the prosecution in this case. And it's never been in a pleading in this case. And it's just inaccurate.
Second, was Kouri in financial distress because of her real estate business? Prosecutors have said at the time of Eric Richins' death, K. Richins Realty owed hard money lenders more than $1.8 million.
Kathy, before this, was your client solvent?
So that's one of the issues we felt compelled to speak to the press about. There has been quite a bit of reporting about my client's financial situation. And the concern that we have is that the reports that have come out about her business, the solvency of her business, utterly fail to take into consideration a huge piece of property that she obtained 2 days after her husband passed away. And that's removed from all of the state's calculations. So the equity in that house alone, the value of that one piece of property was enough to cover any debt that she had in her business. And we just feel that that is improper reporting, that arbitrarily cutting off what condition her business was in prior to her husband's death without taking that into consideration is misleading. Furthermore,
Okay, let's pause there and talk about this segment. Okay, so was her client solvent? You saw all the charges that were being brought against her, right? Insurance fraud, I forget whatever else was on there. So, okay. They're bringing these charges against her. Again, they need to prove it, right? They have to have evidence to prove that she did these crimes. So her talking about them in general terms, what does that say to you? She's currently saying, no, our client was solvent at the time, so I don't know why these charges are coming about. Well, that's where you, as a defense attorney, then go ahead and file paperwork in your motions in limine to exclude evidence that does not fit, right? If you say that she didn't commit any financial fraud, then prove it. Show them that this evidence can't come in because you didn't prove that she did, that it would be, it would be more prejudicial than probative, right? It's going to taint the jury into believing that she did if you can't prove that she didn't. Character. Remember, we were talking about character evidence in the Aaron Spencer case yesterday. So let's continue on.
All of the reporting that is done only focuses on what we call debt service, not the actual value of the property she held. So that's completely being kept out. So it would be like if they said, you know, Ms. Halloran, what is your net worth? And you left out your house. I mean, that's a piece of property is an asset and it has value, and that's never taken into consideration. And so we believe that that has also been misreported, and that's something we felt ethically compelled to come forward and correct.
Third, life insurance.
Well, another one that's out there's false is that she took out hundreds of thousands of dollars in life insurance on him shortly before he died. That's not true. She took out one policy that came in the mail, and it was one of those mailers we all get from our credit union saying, sign here for $100,000 free life insurance. Sign here for yourself, sign here for your spouse. You can get $100,000 free life insurance. That was sent in. She sent that in about a month before he died, 4 or 5 weeks before he died.
Okay, so let's pause there and talk about a month before he died, right? So if we go backwards in time, I mentioned to you that she had offered him a breakfast sandwich that had fentanyl in it and that he had an allergic reaction. So when did she do that mailer? Because he died in March. So if you kind of backtrack, it's around about a month. So, you draw the conclusions. We'll continue.
All the rest of his life insurance, and he had a lot of life insurance, was all taken out by him long before that. And he knew of all the life insurance policies that were out on him. And we don't know if he knew of that last one. But in terms of her taking out a life insurance policy on him, that's the only one, $100,000. So their motive, according to the state, is, oh, she took out life insurance, she was going to cash in on all this money. And again, that's not accurate. I mean, she took out an extra $100,000, which may seem like a lot to a lot of people, and it is a lot, but to this family, the other life insurance was well in excess of that last $100,000. And that amount of money for this family was not really all that much.
Does the prosecution have an ethical obligation to correct these things that are out in the narrative?
Again, I think if what they want is justice to be served, they have an obligation to do that. Of course, their real obligation is in the courtroom, and we'll just have to see what happens then.
And the final point, the Google searches regarding how much fentanyl it would take to kill someone.
There are a number of things. You talked about the Moscow Mule, which we believe is not their theory. They've never said it was their theory. And I think the facts that come out in trial will make it very obvious that that isn't even a possibility. But one thing that's been reported on that they have let go, have not corrected, is that Ms. Richins Googled how much fentanyl does it take to kill someone. And that's been in the press, and it's been extrapolated from that she Googled that before Eric Richins' death. And that's just not the case. We've discovered through court records, through exhibits, that she Googled how much fentanyl does it take to kill someone a day or two after she was told he died of fentanyl poisoning, not before, which makes perfect sense. She doesn't know how her husband died. She's told, your husband died of fentanyl poisoning, and she's looking, well, what does this mean? How much fentanyl would someone have to take to die of fentanyl poisoning? That's a very, very different narrative than to leave it out there that, oh, the Moscow Mule murderer Googled how much fentanyl does it take to kill someone. No, that's not what happened.
One thing that's also been different in this case for the attorneys is how the prosecution is handling it.
The language that the prosecution uses in its filings, do you feel at any point that they have crossed the line?
Yes, this has been interesting. I have not seen the personal language in filings typically in court that we're seeing here. The prosecution does seem to have a very strong opinion on this case, not just here's the evidence. They seem to have a personal opinion, which I think is reflected in their pleadings and has been reported on, some more than others. The poppycock memo was one that got reported on, which is surprising and unusual to see language like that in legal pleadings. So we've been uncomfortable with that. I see the prosecutor's job, like I said, is to fight for justice. It's not personal. It's not.
Okay, once again, I understand what they're trying to do. They're trying to advocate for their client, which is perfectly normal, right? But now here they're not only advocating for their client in the press, they're also calling out the prosecution and like calling names. Is that ethically right? Is that professional? Are you allowed to do that? Are you supposed to? I mean, obviously she did it. So, but I have a sneaking suspicion that the judge is not happy about this. You're not supposed to argue a case outside of the courtroom. And that's essentially what they're doing is they're arguing Kouri's case, putting forth information out to the public that may or may not have known anything. I didn't know, again, about the Moscow Mule killer. I don't know anything about this poppycock motion or something that had been filed. But again, I haven't been covering the case. It's been going on for quite some time. Again, so she had a change of attorneys that delays a case. They also stayed the case because she wanted to do the change of venue. That went up and that got shot down. So now the change of venue is back. And so when they say they stay the case, they pause. So nothing happens with the case. I think that might have taken like 6 weeks or something like that. So there's been a lot of delays in her case. And here we go again. Let's continue on.
Personal for them, and it shouldn't be personal for us either. We're all there doing our job. We're there to protect our client's rights. We're there to make sure our client gets a fair trial. They're there to serve justice. And what they think is justice and what we think is justice is very often the opposite. But it begins to get personal sometimes, I think, when it's a case that it is high profile. There is a lot to it. They've been working on it a very long time. And I can see that sometimes you can't help but.
Okay, so I'm going to pause it there. High profile, right? How does a case become high profile? Well, it's got a great storyline, right? Mom kills dad for money, right? That's exciting and intriguing. How did she do it? Fentanyl, Moscow Mule. Oh, even better. That sounds exciting, right? Then she writes a children's book. Wow, that's even more exciting. And then she's accused of killing him, right? That's really exciting. And then she was in real estate and she was doing all these deals and stuff like that. So it becomes high profile in that sense. But if you keep talking about it and you keep mentioning it in the press and everything, it garners more attention. Let's continue.
Get personal. Sometimes we can't help but feel personally upset about our clients. It's hard. It's a job, but it's hard. Some prosecutors are better than others at not making it personal. It's just been my observation, and maybe I'll be proven wrong at some point in the future, but this has become quite personal for them.
So why did the defense attorneys come to 2 News Investigates? Why now? Why not just correct the record at trial?
Look, I never thought I would be sitting here. I don't think I should need to talk to the media. I really believe that I should be able to get a fair trial. But the way that this case has gone, I don't think we can do that. We have to make sure that when we step in there in February, that we have leveled the playing field, and we can't just hope for that.
Is that why you came to me?
That's exactly why we came here. And really, it's an ethical duty. There's a rules of professional conduct that says if we think that there are facts out there that have been laid out in such a way that we think goes against our client's best interest, that we have a duty to come out. I think some defense attorneys do hide behind, hey, I'm just not going to speak, no comment. And I think that's fair. I do it a lot. But this is different.
Because we don't get an opportunity to argue the facts until we're in front of a jury. The judge decides the law, a jury decides the facts. And what's in the narrative right now and in the public media is facts. So we won't have that opportunity until we're at trial and the jury is sitting in the box. And like I said, our concern is, can she get a fair trial when all of this is out there before we ever get an opportunity to show our side of the story and to show what we believe really happened in this case.
What do you believe happened in this case?
We believe that she's innocent, and the rest will come out during the trial. Because like I said, it's the people in the box that we need to convince, not the viewers, not anyone else. We just want to make sure that people don't come into that trial.
Okay, I'm sorry. You don't need to convince the viewers. Who is this going to? It's a local television station. Who are the viewers? The jury pool. I'm sorry. I don't know. She's delusional or what she's thinking. Let's continue.
Believing things that are absolutely false. We don't want to spend the time in the trial convincing people that what they've already heard is wrong. We want to spend our time, presenting our case without having to go back and argue against what's in the media.
Is the prosecution in this case injecting a false narrative to the media?
I don't know if they're necessarily injecting it, but they're certainly not correcting it. And I think that's why we're here today, is we honestly feel that we have an ethical duty when we have a client who is facing such serious charges and there is misinformation out there and it is not being corrected. It's a disservice to justice.
With that said, then how critical should the public be with this narrative? Or is the public just taking the prosecution's statements and narratives at face value because it's the prosecution, it's the state of Utah?
I think that's part of it. I think also it's easy because of the headlines to just go along with it. And when somebody who we trust, right, the county attorneys throughout this state, the district attorneys, we trust that they're going to make the right choices when they charge. But also, it doesn't end there. It's also through the prosecution of a case. And with such a high-profile case, I think the public needs to be even more critical. Because if what's going on in this case goes on to a lesser degree in other cases that don't get the exposure, that don't have the appropriate resources, that's when our country starts to become in danger.
Okay, so I just have to stop there for a second. Is Mr. Ramos saying that we're taking this stand and we're doing this now because this case is so important? It's a high profile case, but other cases that aren't high profile, they deserve attention as well. And so everybody should go to the media and talk about their cases. I cannot wait to hear what this judge has to say, and I want to know whether or not he admonished them for doing this. What is going to be the end result? Well, we're almost done, so let's just continue, and then we'll talk about what the end result might be. Let's go.
And if I may ask you this, I'm not sure if you will answer, but has the Summit County Attorney's Office vilified your client?
It's not their job to either vilify or create or make them insane, but it is their job to stick with the facts. And that's something that they have not done in this case, especially with how it's been portrayed in the media. If their goal is justice, they have not lived up to it, at least in this case.
Why reach out to 2 News Investigates?
I don't know. I mean, we have a lot of confidence in you, and we're hoping that you can get the word out and that it's, it's kind of the one pebble in a pond, right? That once you throw a pebble in and the waves spread out. And we're hoping that once we correct it in one place that's credible, that's a well-known news source, that maybe the other news sources will also start to question a little more about what they're hearing and what they're covering, just so that the importance is that the facts that are reported accurately. And we really appreciate the opportunity to come forward and correct what we think has gotten out there incorrectly.
When you hear these false narratives and you know what you believe to be the truth,
it's extremely frustrating. I think being a defense attorney, being a judge, a bailiff, it feels routine. You possibly in your job when you're doing things feel routine, but you're doing so much in your job that means something. And it's no different in the courts. We walk in, we joke around, we know everybody. At the end of the day though, we're doing something very special in there, every single hearing, and especially when we're in trial. And what we're doing is we're upholding the Constitution. And that's a very high bar. And I feel that when I see these narratives come out, it becomes a game. It becomes another line. And we forget that there's somebody on the end of that. And that's a client. That's a human. That's a mother. And it does really frustrate me.
is Kouri aware of these narratives, and how does she handle what you claim is misinformation being spread about her?
She is distraught. She is heartbroken. This has been very, very difficult for Ms. Richins. She's been in jail now for over 2 years on these charges and doesn't have an opportunity to really tell her story until we're in trial. So yes, it's been very difficult on her.
I
Okay.
asked Summit County Attorney Mark.
I want to go back to what they stated her charges were. Let's go back. Let's see if we can find it. Oh, I might not be able to find it. Well, shoot. Hold on. Well, I know it was early on. I'm going to let it play in the background here. You can't see it, but I'll let it play in the background. When it comes to it, it'll come back up. Okay, so oh, goodness gracious. So, they were the defense team was the one that came to the judge and said, hey, listen, we want to change a venue. There's been too much publicity on this case, blah, 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 blah. She's not going to get a fair trial, la, 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 la. We need to move it. They had this big hoo-to-do, hub-to-dub about moving it. Time stood still. They realized it went up to, I forget where it went to, but they said, no, it can stay where it's at. So on the docket that Emily D. Baker was talking about, it has back on there change of venue. The ruling about the change of venue has been back on there. Now, we're not sure whether or not they are going to go ahead, and now the discussion of change of venue has that come up again because of this. And are these attorneys going to be sanctioned? See, that is another question. If you are not doing your duty as a lawyer, the judge can impose sanctions upon you. I mean, usually it's monetarily. Sometimes they throw you in jail, You've seen it like on courtroom televisions that I'm going to throw you in jail. It's kind of ridiculous, but if you do your job correctly, you get admonished for it, right? The judge can't necessarily fire you or kick you off the case, but he can impose monetary things that hurt your pocket. Even though these are court appointed attorneys for her, they still can get sanctions, and also you can lose your bar license if you don't practice properly, right? If you've done something improper. I don't know if they've called for sanctions. I don't know if they've called for anything being improper. Usually that has to be filed. And what Emily was talking about, the case of Ramos having an attorney, in come in and explain yourself, when she was talking about Ron, that happened in the Cardi B case. Cardi B was being sued civilly for assaulting someone, and the attorney for the person that was suing, the attorney had done some very improper things in the courtroom, and the judge is going to impose something on him, probably a monetary sanction, and he needed to come into court and explain himself. So that's kind of a little bit of background of what that is. Um, it just, I just, uh, it's frustrating because you want Kouri Richins to have a fair trial. We want everybody to have a fair trial. She is presumed innocent until proven guilty in a court of law, right? All defendants are. And again, some people might not know the facts of the case. They don't read the filings like we do. I'm not in Utah, so I'm not going to be a juror on her case. But in this case, they're going to the local news station. They're bringing up facts of the case, whether they can prove it or not in court. They're bringing up issues that may not have been brought to the attention of other people. And this, again, can possibly taint the jury. And when and if this does, it could be very detrimental to her case. Yes, Kouri doesn't have the ability to go on the news media and state the things that are happening to her. She can't hold press conferences like Karen Reed did, from time to time. If there becomes too much information being said to the press or to the public via social media or other avenues, the judge can impose a gag order, right? They did that in the Karen Reed case to an extent. You're not allowed to come out and say anything about the case. You can't try this case in the court of public opinion. And this is what they're doing, unfortunately. You don't see the prosecution coming back on and saying, well, they said false things and they need to correct the record. They didn't. So, unfortunately, it's a dire situation right now. So this was the latest. Let me remove this. Let me bring this back up. This was the latest on what was happening in her case. They were supposed to have a pre-trial conference hearing on December 5th via WebEx, meaning they were going to do it via like Zoom. And then the stuff was starting to happen in January. They were going to have exclude expert witness statements. The state's motion of the admissibility of the walk the dog letter was going to be argued. And then jury selection was going to start on February 10th, trial to start February 23rd of 2026. Again, I don't have access to the docket. I kind of get my news information from Emily because Emily has that. So I'm kind of piggybacking off of her. Shout out to Emily D. Baker. Love you, girl. By the way, did you see when you heard Emily D. Baker? She's got some colorful language. I just love it. Not that brazen just yet, but maybe eventually we'll have that language. So we'll kind of just go off with the news and what everybody else has to say because I don't have access to the docket. But there is going to probably be a hearing at some point in time where they're going to hash out all of this stuff. There's been some closed hearings. You heard on October 31st, there's been some closed hearings behind the scenes of not public. Remember when I said what's public and what's not public? So they've had some not public hearings going over what's going on in the case, et cetera. And Mr. Ramos has had to hire his own attorney to come in and show cause as to what the heck is going on. So it gets really bizarre. So, again, this is where we're at with the Kouri Richins case. We're somewhere, we're nowhere. A lot of stuff is coming up behind the scenes, and hopefully we'll get some resolution soon. So I hope you're having a great weekend. Happy Friday to you. I'm going to do a case catch up for those who just want a small brief about what's going on in the world in my cases. So hope you're having a good time, and we'll see you on the next one. Do the YouTubey things, please. Like, subscribe, get a notification. Got to get to 50 subscribers by the end of this month. Thanks for watching. We'll see you again. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.